Hi guys, this is Mr. Tan, and today we are looking at intellectual property. So, what is intellectual property? These are products of the human mind, the fruits of human creativity and innovation, and they include, inventions, literary and artistic works. They include designs and brands, symbols, names, and images, used in e-commerce. So, what is the intellectual property system? IP, intellectual property, is protected by different laws and mechanisms, which includes laws and mechanisms under patents in terms of, copyright, in terms of, trademarks, um, you know, geographical indications, industrial designs, and trade secrets. And what's the purpose? The purpose is for it will enable people to earn recognition, financial benefit, for what they have invented or created. And it aims to foster a balanced environment in which creativity and innovation can flourish. So when we think about the intellectual property family tree, then we're saying at the top you have, intellectual property, and then from intellectual property there are three main areas. And these three main areas include, intellectual property, they include copyright, and they include, protection for traditional knowledge. But then under industrial property, there are three further sections, and industrial property will include patents, designs, and brands. Now, when we think of copyright, then we have to really refer to an individual's piece of work that relates as the person's first owner of copyright under the 1988 Copyright Designs and Patents Act. So, normally the individual or collective who authorized the work will exclusively own the work and is referred to as the first owner. So, but if a person works for a company or is a freelancer and that person is being paid to design a patent, or a design, then the company will own it because they've actually employed that person to actually produce that asset. So, just like any other asset, copyright may be transferred or sold by the copyright owner to another party. Rights cannot be claimed for any part of a work which is copy taken from the previous work. For example, if a piece of music featuring samples from a previous work, then the copyright of the samples would still remain with the original author. And it's really only the owner or the exclusive licensee who can bring proceedings in the courts if someone has infringed their copyright. Now, when we think about patents, we can look at the example of turmeric, which is a yellow powder developed from the plant Cucurbita elengirae, and it's commonly used as food colorant in many Indian dishes and imparts a bitter taste. But turmeric is also used as an additive in prepared mustard. Although it's primarily a dietary agent, turmeric has long been used in India as a traditional medicine for the treatment of various sprains and inflammatory conditions. So the active ingredient in turmeric powder is, curcumin, which is a completely, symmetrical molecule. So, and then this is really used to describe the use of and the invention, the patent invented and patented. And the present invention provides a method for, promoting healing in the wound in the patient, which comprises of administering a wound healing effective amount of turmeric to the patient. The present inventors postulated that turmeric may have significant anti-plastic, antioxidant, antibacterial, and anti-inflammatory properties when given orally or applied, topically. In view of these facts and the availability of turmeric, the present inventors studied the wound healing properties of turmeric to provide a simple and economic solution to the problem of, chronic ulcers. So, and this turmeric, in terms of this process, has been patented in terms of an invention. Now, when we look at the basis of patents, then we're saying to ourselves, what is an invention? And this is a product or a process that provides, in general, a new way of doing something or offers new technical solutions to a problem. So, what is a patent? An exclusive right that allows to prevent or stop others from commercially exploiting the patent invention, granted by the state or by the regional office acting for 7 states, applicable in the country or region in which the patent has been filed and granted in accordance with the law of that country or region. And this is for a limited period, generally 20 years from the filing date of the application. There are 3 principal requirements for inventions to be protected, conditions of patentability, and these include novelty, new characteristics not known to the body of existing knowledge, prior art, in its technical field. The inventive step, non-obviousness, cannot be deduced by a person with the average knowledge in its technical field. The industrial application utility, the invention must be of practical use or capable of some kind of industrial application, and there must be disclosure of the invention, description in detail. And if these conditions are not met, a patent will not be granted. So, if this is discovered later, patents can be revoked or invalidated. So now we move on to trademarks. And what is a trademark? A trademark is a sign, capable of being represented, graphically, and which is capable of distinguishing goods and services of one undertaking from those of another undertaking. And what does a trademark do? Well, the proprietor of a registered trademark has the exclusive rights of that trademark, and it stops it from being infringed by the use of that trademark in a given territory without their consent. What are the possible routes to register a trademark? Well, you can register it nationally. It can be a regional system of registration, for example, in Europe, the registration of a community trademark, or you can file it internationally. When we think about, what is a sign, these can include, words, designs, letters, numerals, the shape of goods in their packaging, slogans, colors, sounds, smells, gestures, taste. So we can see things like Disney, Apple, McDonald's, and MGN, and even like the shape of a bottle, like Coca-Cola. And even if we think about, what is a graphic representation? Well, a graphic representation is one which utilizes images, lines, or characters in order to render a sign registrable as a trademark. The graphic representation must be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. In addition, a representation must be sufficiently accessible and, intelligible, and not require excessive efforts to be taken to the public to actually understand what is actually being meant. Now, if we think about the relative grounds for refusing to register a trademark, here we can compare the sign that is being applied for with signs that are already on the register itself. Trademark infringement, well, the proprietor of a registered trademark has exclusive rights in the trademark which are infringed by the use of the trademark in a given territory without his consent. And there is no requirement of knowledge or intention on part of the defendant, as liability is strict, and likewise there is no need to demonstrate damage. When we look at invalidity and revocation, well, the trademark may be declared invalid if it was registered in breach of one of the absolute or relative grounds for refusal. It can be revoked for non-use, suspended for, suspension of use if the trademark has become common name in trade, and if the trademark has become used in a way that it is liable to mislead the public. So here we can see invalidity and revocation of the trademark.